Good morning. This is Rich Sierra, President of the Florida Small Business Legal Center. This is Business SOS. Thank you for listening. This is episode number 49 of Business SOS. We're almost to the 1 year mark. I'm very excited and thank you for listening. I'd like you to participate in the show. If you have a legal question that you'd like me to address in the show, please send it to me at richsierra.com. And if I select your question and I'll address it in the show, I'll send you a free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. So last week, I talked about why employment agreements are important to a small business. Whether you have a receptionist, a cashier, having an employment agreement is important to establish the duties and responsibilities that the employee has and really set expectations. But at the same time, for you to be clear in what you're offering so that way there's no disagreements later on. And also some protections that are in place like non-solicitation agreements, non-circumvention agreements, maybe non-compete, but I'm not going to, I addressed that in the episode regarding a non-compete when and when it's not appropriate. And that's a separate subject altogether. But the protection of confidential information, there's a lot of reasons why having an employment agreement, even if you're a small company, it is advisable as well. So today we're going to talk about independent contractor agreements. And in episode 38, if you haven't had a chance to take a look at that, I spoke about the final ruling from the U.S. Department of Labor regarding the employer independent contractor classification under the Fair Labor Standards Act. So there is I went over great detail. This is actually information that came out earlier this year, actually effective March 11, 2024. So it's really, the ink is still wet as we speak. So I went over specific about how the Department of Labor is looking at independent contractors. So it's important if you haven't had a chance to listen to that episode, go back a few weeks, episode number 38, listen to that. And there's also a link directly to the source that I utilize from the Wage and Hour Division, the Department of Labor, so you can actually download it and read it as well. And if you have any questions regarding any of those issues, of course, let us know. So today I want to talk about, independent contractors. So briefly, what is independent contractor? It's someone that you hire to do a project, for example. In an example of that, I'll give you you use Fiverr or Elance. You have somebody doing some graphic design for you. You hire them on a project per project basis. Somebody comes in for a few hours to do some work and just basically leaves and they kind of step in to fill in some gaps that you may have in your business, or perhaps they might have specialized skills that you basically do not need them all the time as an employee, but they come in, fill in that gap, do that work, and they leave, and they're completely independent from you. So they have their own company, they work with their own clients, and you do not provide tools. So they're really independent. And I want to emphasize that because I comment when I talk to small businesses in my practice, I hear when I talk about how are you paying your employees or how many employees do you have, and kind of getting a feel for the company. And this comes very often when people are trying to sell their businesses or buy businesses. And they say, yeah, we'll have a couple of 1099 employees. And I said, what does that mean? Well, they kind of work full time, but they asked me to pay them 1099s, not to take payroll taxes, not to pay anything. So they pay their own taxes. And I'm like, well, you cannot do that. It's not a good idea. There's no such thing as 1099 employees. They're either W-2 employees or they're independent contractors. So I just want to make it clear. Simply because and the employee does not have, or the person who's working for you does not have the choice to choose, does not have the ability to choose how he or she is going to get paid. Okay? If the person is working for you on a full-time or part-time basis, and you're telling the employee, that individual, okay, you got to be here between 9 and 5. You're setting the hours. They're coming into your office. There, you're providing the tools. You're providing the client list. You're providing everything that they need to perform their duties and their job, his or her job. That person is an employee. That person is not an independent contractor. So to go ahead and pay that person as a 1099, you might have an issue with potential payroll tax liabilities, violations of wage and hour laws. And so it's not a good idea to try to circumvent payroll taxes or your obligations to pay payroll taxes to try to save a few dollars. Just do it right. It's just not worth the risk. And it's good to talk to an attorney, to an accountant about, I'm going to hire this individual. This is the way the person is going to be working for me. Is that person an independent contractor or an employee? When in doubt, most likely a person will be an employee based on the guidelines that are very, very broad in terms of what an employee what is considered an employee versus independent contractor. But let's assume this for the sake of this, for today's episode, I really want to focus on, an independent contractor agreement, what you should have with that. So you will have a person coming in to work for you for a project. And this also applies to vendors. You can have a vendor agreement. So one of the things that to look for or to include in an independent contractor agreement. So let's go right there, right? Let's talk about that more specifically, because that's really the topic of today's conversation. So one of the things I highly advise, whether it's an independent contractor or a vendor coming to work for you, have a contract. The vendors may have their own contracts. Independent contractors may not. Okay? So, one of the things I like to include there is what this independent contractor is going to be doing for you, the description of services. Whether a person is going to be doing some outside sales on their own, on a commission basis, whether the person is going to be doing some graphic design, maybe do some IT work, whatever the case may be, it's good to have a description of services in the agreement. The payment for services is very important as well. How the person is going to be paid and when the person is going to be paid. The term and termination, how long will this relationship be for? How long will it last? So is this going to be on a project-by-project basis, on an on-call basis, or it's going to have a limited duration, whether it's 3 months, 1 year, whatever the case may be. You might have, and sometimes you have software designers or software developers that might have a project that takes about a year. So you include it there. And also how this agreement will be terminated, it is important to include it there as well. I'm just giving you highlights. This is not designed for you to, okay, I listened to the podcast, so I'm ready to write an independent contractor agreement. No, you're not. So I just want to make it clear, these are simply things to look for, even when you're given an independent contractor agreement, or you basically say, I need one, something to keep in mind when preparing one or when reviewing one. My advice, of course, which is the subject of the basis for my book, if there's something that you're not really familiar with, especially in the legal end, my advice is to seek counsel, to get an attorney to draft it for you. The way I draft, in my case, when I draft my contract for my clients, it is a standard contract, and then which would house all the terms and conditions. And then in the back, you really have more customization. The duties might change, the job description or the type of work that the person will be doing. And I call it job description. I digress to that. It's really the services that are going to be provided by this contractor. And then the compensation. Those things are going to be changing over time depending who you're going to hire. But for the most part, all the other terms will change. So I try to make my contracts that are practical and that can be reused over time. So that way, my clients don't have to be calling me every single time they hire an independent contractor or an employee if it's an employment agreement. So, contracts have to be practical, has to be simple, And once you have one, you can continue using it unless there's some changes that have to be made for whatever reason. Um, you may provide, in some cases, this independent contractor might have access to confidential material. So I like to include in my contracts that they're going to protect that information. So you have a confidentiality agreement within the contract, but also if they are given access or given the ability to retrieve some of this information for their use, and that they will return that information or provide certification that has been deleted if by any chance it goes into a different server, if it's some data. So, but I like to include a confidentiality provision within the agreement and return of whatever material that have been provided to be able to provide those services. The relationship between the parties is very important. It's very clear that in this case, we're talking about independent contractors, that they're completely separate. They're not employees of the company. They're not agents of the company, and that they're responsible for payment of their own tax liabilities. That you're not responsible for that, and that will be part of the contract. Sometimes you have independent contractors that create logos, create software. They create something for you. It is important to include that whatever they design, whatever they prepare for you, that is your product, that is work for hire, and that that is not their property. So that's something that is very important to include there as well. And I include it as part of my agreements to make sure that when the person leaves or that relationship terminates and the work has been completed, you don't want to have an issue that say, oh, by the way, that logo that I made for you, I really own it, or that photography that I made, or those pictures that I took for you, that you owe me royalties. I just want to make sure whatever they are doing for you at the time during this relationship, during this time period, that belongs to you as the business owner. That is very clear. I talked about confidentiality early on, but it's important to, in terms of confidential records, but also I like to have confidentiality as to the type of work they're doing for you, and also all the access to the information that they will have. So we'll have a confidentiality agreement as well within the independent contractor agreement. It's very important to have that. I also have it in my employment agreements as well to make sure that whatever, especially now with digital technology and everything is online, everything is accessible. We're really not dealing that much with a lot of paper, except me that I have a lot of paper here next to me to read my notes. So a lot of information is digital, so it can be easily transmitted. And once information, you have that knowledge base, you can do a lot of things with that. So it's important to have that information, that information cannot be used outside of the scope of the services that have been contracted. Sometimes when you bring somebody into the company as an independent contractor, and listen, relationships are made. People get to meet other people. They have access to your employees. They have access to to the person that you work for, that work for you. So one thing that I like to include is that a non-solicitation agreement, meaning that with respect to your employees, that independent contractor cannot be contacting your employees to try to have them work for somebody else or have them leave the company. So that you're going to protect that, that human property, not, I'm going to say, I digress, not human property, but intellectual property, that the human talent that you have, especially in a small business, you want to protect it as much as you can. Obviously, people can leave if they want on their own volition, but you want to make sure that there are safeguards in place that if you bring somebody in to do work for your company, that they don't go ahead and say, by the way, I heard that their competitor is looking for somebody, and begin to try to push your employees. So to the extent that we can prevent that, through an agreement, at least we'll try. So non-solicitation to the employees, but also a non-solicitation clause as to customers. If this independent contractor has access to your customers, that's extremely valuable to you. So you have to protect that. So in the same token, we want to have an agreement. We want to have something in place that there's a restriction on this independent contractor contacting your customers after this relationship has terminated, and during the time the relationship is going, they're providing the service, only contacting them for the purposes that they've been hired, not to kind of work out side deals or, just to make sure that your customers are protected, your employees are protected as well. You're protected from them contacting them, your employees or customers for solicitation, and then you're losing customers or employees for a contractor you brought in to do work for you. Something that I advise my clients when they hire independent contractors is that the contractors should have some type of liability insurance. And it varies from the type of work that the person might be doing. So, but in my contracts, I include that the contractor will have their own errors and omissions insurance, general liability insurance, and provide proof of that insurance to my client. But that is more of a preference. It's not a requirement. That's something that you might want to consider, but I have it included there. Something else that I include that I highly recommend is that, especially when contractors are working for different types of businesses, that for them doing the work for you, it does not create a conflict in working for with somebody else. If they have a contract with another client or customer, you don't want to have an issue that they might be violating a non-compete. They may be violating some type of agreement that they certify or they basically attest in the agreement that they will not, there's no violation of an agreement for them working for you. So that at the very least, it is covered and you don't have an issue later on. And the reason I say that is because it's not uncommon for a lot of employers, or a lot of small businesses to have NDAs and non-competition agreements, and they have the standard forms. They bring an independent contractor, they make them sign it. Independent contractor signs it without reading it, and then they find out later on, listen, I went to do work for, a project for this company, and I signed this 2-year non-compete agreement. Now I cannot do any work for this other client. So that's a different conversation. And in that case, they have to disclose it, and then, you can have a conversation with the attorney. Is this enforceable? Is this valid? And that it's a different analysis altogether. The point is, you want to make sure there's no conflicts. And that's part of the agreement. I include an indemnification provision that in the case that there are any type of claims against you for the negligence of the contractor, that contractor will indemnify you and will hold you harmless. So I'll include that as my contracts, and that goes into the insurance. So you want to build up the insurance from the contractor in the event that you have to utilize that insurance to protect you. A lot of these items, just to let you know, they're remote, meaning that some of the chances of you being sued because of a contractor may not happen every day. And, fortunately, it will not happen at all, but it could happen. And the reason you want to have these contracts is to protect yourself, protect your business. And I get a common question that I get from my clients: Rich, how can I protect myself from anybody suing me? The answer, it's impossible, because somebody can sue you for something. You can protect yourself from liability by having strong contracts. it's kind of a two-prong approach. You have your contracts and you have your insurance. It's kind of that buffer. And then you have the third prong is good business practices. So those are the things that you can have to protect yourself against the possibility of lawsuits. But in terms of 100%, it's impossible. But at the very least, you can reduce the likelihood of being sued by having insurance, having your good contracts, solid contracts, and having solid business practices. And I think that you really diminish your exposure to a lawsuit for breach of contract, negligence, in a significant fashion. Another section that I want to talk about here is the applicable law and dispute resolution. We're in Florida, so pretty much our contracts are, based on Florida law, and also the jurisdiction regarding any exclusive jurisdiction regarding any legal action, whether Palm Beach, Miami-Dade, or Broward, whatever the case may be. But I also like to include a dispute resolution procedure in the case there's a dispute. And I've spoken about this before. We have I'm really a big proponent of mediation, because mediation, a good mediation is worth, it's a much better investment than litigating. And I talked about that before at great length in prior episodes. So in my contracts, I have a step approach. If there's a dispute, we'll try to resolve it and talk about it. If we cannot resolve it, we both agree, the parties agree, go to a mediation conference first before filing a lawsuit. And the reason for that is that you file a lawsuit, you'll end up in mediation anyway. Sometimes 60 days before trial, after you spend thousands of dollars, tens of thousands of dollars in litigating. So my suggestion, any dispute, go straight to mediation. If you guys cannot talk about it, you cannot resolve it amongst yourself. And then after the mediation conference, if it doesn't get resolved, there's another step. You can either go to circuit court or county court, whichever the case may be, or you can go to binding arbitration. And I talk out to the client about the pros and cons in both of them. And in fact, and I believe episode number 47, which is just 2 weeks prior, we actually went over the pros and cons of arbitration versus litigation, and I went to a deep dive into the topic, so you can take a look at that episode as well. So the contract includes that, and the reason you want to have that is that when I deal with a lot of breach of contract claims, and first thing I look at the contract, I go to the second or third page right from the very beginning. How are we going to resolve this? There's dispute resolution section of a contract is usually ignored. It's usually kind of like, people just don't pay attention to that. And it's probably one of the most important sections because it tells you, okay, if there's a dispute in this contract, then this is how we agree that we're going to resolve it. And to have the illusion that we're never going to have a conflict, that's not real life. Every single contract has a possibility of having a dispute. Doesn't mean that every contract you will have a dispute, but every time you enter into a contractual relationship with somebody else, there's always that possibility. You're human. Sometimes people misunderstand one another. Sometimes people just for a reason do not meet the obligation within the contract. There are just a number of reasons why something can go wrong. But it's important to at least have, if you're going to have a contract, have a method on how to resolve it. It's really simple. A lot of times it's not there. I'll make sure that in my contracts it is included just to make sure, because I want to make sure that if I'm not the attorney working for this client, say 10 years from now, that whoever looks at this contract can say, okay, you know what? The attorney had the foresight to know that, hey, listen, something can go wrong. So in this case, he actually developed a step process in how to resolve it that is actually organized, it's methodical, and it's actually more cost effective. When you do not have a dispute resolution into the contract, then you go straight to the court, and that's very expensive and costly and very stressful. So one thing also I want to include is that prevailing parties attorney's fees. This is actually another section that is very ignored in contracts, meaning that if by any chance there's a dispute and prevailing party is entitled to recover attorney's fees from the losing party. If you do not have that into the contract, then each party pays their own fees and cost. So the only two ways you can recover attorney's fees in Florida in a contract: if it's contractually based, meaning that you agree to it in the contract, or if it's statutory, meaning that you're enforcing a statute that allows for the recovery of attorney's fees. If you don't have that, each party pays their own. So this is good for today. If you have any questions about independent contractor agreements, employment agreements, one of the topics that we have spoken to in the last few weeks, please send me an email at richsierra.com. My website is floridasmallbusinesslegalcenter.com. We're in Facebook at FSB Legal. We're on YouTube.com. If you want to see the video of this podcast, we're in youtube.com/@RichardSierra. We're on X at Rich_Sierra. We're on Instagram at FSB Legal. If you want to give us a call, we're 866-842-5202. Remember the Business SOS, a common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. If you like our podcast, please appreciate a 5-star review. Follow us and share it with your friends. And same thing with the YouTube video. If you like the video, just please subscribe so you get the videos as they come out every week. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.